So what happens when a complainant, or indeed the respondent, doesn't show up at a WRC hearing? Obviously, it's very unfair for the other party. For example, recently I was at a WRC hearing. On this occasion, I was representing the employer, and we had 2 or 3 witnesses. We had done a good deal of preparation for the hearing, and we were vigorously contesting the various claims set out by the employee. And we went along to the hearing at the WRC headquarters at Lansdowne House, and 5 minutes before the hearing there was no sign of the claimant. He did have a representative there, and the representative indicated when the hearing started that his client was out of the country and wasn't going to be there. So clearly this is very unsatisfactory from our perspective, because I had taken a significant amount of time off and blocked out the day in my calendar in order to do the hearing. And you never know how long they're going to take, so you'd nearly always have to allow a full day, because things can run on depending on how many witnesses, the complexity of the issues, the adjudicator and other factors. So I'd taken the day off, as it were, out of the office, hadn't taken any consultations or couldn't do any other work. My client was there, a company director, another company director was there as well, the secretary, and the witness. We were all there ready to go. We were all prepared for the hearing to put our side of the story, to put our case. And the adjudicator obviously did make inquiries from the complainant's representative as to where he was, and indicated that he was satisfied, the adjudicator was satisfied that the complainant had been advised. I asked the adjudicator to strike out the case then on the basis that it wasn't being prosecuted, that the legislation provided for the hearing to be held and for the claimant to certainly have a hearing and to put forward his case. But in circumstances where he doesn't show up, I was asking that the thing be struck out for want of prosecution. And generally 99% of the time, or certainly 90% of the time, it is the case that if a complainant brings a claim, and if the adjudicator or the WRC is satisfied that he or she was notified about the hearing and the date and the time and the place, and in the absence of any excuse or any exceptional reason as to not being there, then the likelihood is the case will be struck out or not proven or be deemed to be misconceived, essentially because there's no evidence, there's nobody there to put the case for the claimant or for the complainant. And I'd be very hopeful that we will get a satisfactory result there, and that the adjudicator will agree with me and strike out the case for want of prosecution. I'm hoping anyway. But I think that's what happens most of the time, and obviously there are exceptional circumstances where a person could have a genuine excuse. But most hearings, most WRC hearings, you are given at least 3 weeks notice, and mostly, generally I think 4 weeks notice of the hearing. So if you're going to be out of the country, or if you're going to be unavailable, then you certainly have the opportunity and plenty of time to let the WRC and the other side know that you are in difficulty, and you'll be looking for an adjournment. And obviously, had he contacted me beforehand looking for an adjournment, I could have agreed to it, and wouldn't have wasted my day going to Dublin for this hearing and blocking out my calendar. But he didn't do any of those things. He simply wasn't available, wasn't there. His representative was there all right, claiming that he was out of the country. That was it. So I'm hoping, obviously, that we win the case. I'm hoping that it's going to be thrown out. And I think generally that's what does happen when the complainant doesn't show up. Likewise, if the respondent doesn't show up, you're going to have a similar situation. In other words, the complainant is there to put forward their case. The respondent, for whatever reason, doesn't show, then you're going to have the complainant putting forward his case and his evidence or her evidence, which will be uncontested and unchallenged. In those circumstances, the adjudicator, in the absence of any case or any defence from the other side, from the respondent side, is going to have to find in favour of the complainant, unless there's some technicality, in which case the adjudicator can't hear the case. But it's very unlikely that would happen, because quite frankly there's nobody to actually point out to the adjudicator that the case is beyond his jurisdiction. Although I suppose if he looked at the law and if he was simply unable to hear the case, even though the respondent hasn't shown up, then perhaps it wouldn't be successful from the complainant's perspective. But generally, if you don't show and put forward your version of events, your side of the story, your case, well then you're going to lose. Hope you find this video useful. If you do, you might give it a thumbs up down below.